So this is very a warm welcome to all. This is the 12th of the 39 from 39 webinar series, and the idea being that we will spend about 39 minutes discussing a particular topic and dealing with as many questions as we can in the course of that. Today we are covering noises and smells and the statutory and policy framework that local authorities and others might use to address them. We are absolutely not covering common law nuisance, whether public or private, though of course that is in the background to various bits of the statutory furniture that we're going to be addressing. Now, the original plan had been that we would have 3 speakers. Katherine Barnes, who is waiting in the wings, Rose, Grogan and myself, and you should now be seeing the topics that we were going to be covering. Now, unfortunately, Rose Grogan has had to take her young son off for a COVID test, and we're obviously wishing them very well, but that is happening right now. So Rose cannot join us. She has prepared her slides, and what she will do is at a later point, hopefully not too much later, she will record to her slides, and those slides plus recording will go out to all attendees of this webinar. But at the moment, the 2 areas we will be covering are statutory nuisance, which Katherine will be dealing with, and then I will be addressing various other tools, which I will come to in due course. Could I just remind all about questions? Please feel free to submit questions. They will be dealt with on an entirely anonymous basis. So if Katherine or I pick a question, we will not disclose the name of the person who has asked it, and we will also strip out any identifying details. Right, now, Katherine, are you there? Could you reveal yourself? Brilliant. Over to you, Katherine, and I'm controlling the slides, so please shout as we move through for the next slide.
Thank you very much, James. As yes, you will see from the intro slide, I'm going to be talking about statutory nuisance, which is a really critical tool for fighting unpleasant noise and smells. And as should be apparent from the title, what I'm proposing to do is give a whistle-stop tour to the legal regime. And so I should probably be very clear at the outset. James, can we go on to the next slide while I just outline the structure of this talk? The primary aim really is to introduce the regime to people who aren't very familiar with it, or for people who just dabble in this area. And I've done that deliberately based on feedback from various clients who've said that it's typically an area that lots of environmental planning and environmental practitioners do a little bit of work in. But unless you're an environmental health officer, and I think we probably do have some of them as well on the call, you're unlikely to be dealing with statutory nuisance all of the time. And so it's easy to get rusty and just to not deal with it particularly often. So that's going to be the focus today, a whistle-stop tour. And if you are somebody who does nothing but statutory nuisance day in, day out, then I'm sorry if perhaps it seems a little bit basic for you, but I would strongly suggest that you stick around, because James is going to be picking up on some more interesting and nuanced topics for part 2 of this webinar. So as it says there, I'm going to begin by looking at what statutory nuisance actually is, how it's defined. Then in part 2, I'll look at the role of local authorities, and in part 3, I'll look at the legal tools available to individuals, which interestingly are really quite extensive in this area and can prove really, really valuable. So without further ado, next slide please, James. I've set out there a summary of the key bits of the legal framework that you will need to look at. But really the starting point, without a doubt, are well, it's part 3 of the Environmental Protection Act 1990, and so you're going to have to look at that very carefully if you start dealing with statutory nuisance matters. Next slide please, James. So what then is statutory nuisance? And perhaps slightly strangely, I'm going to begin with what it isn't. It's really important to distinguish at the outset between common law nuisance claims in tort and statutory nuisance. The most common type of common law nuisance claim is a claim for private nuisance, which no doubt you'll remember from law school, and that has nothing to do with local authorities. It's ordinary private law litigation between two or more private parties, and to put it very crudely, typically the victim of a nuisance will be seeking an injunction to stop the nuisance and or damages for the reduction in property value that arises as a result of the nuisance. And those sorts of proceedings, I should say James, my colleague, does a lot of them, can be very costly and can also take up a lot of time, particularly if you go all the way to a full trial. Now, I mentioned that partly to avoid confusion, because we're not talking about private nuisance claims, but also because the definition of nuisance in common law is nonetheless really important to statutory nuisance, because statutory nuisance builds on the private law definition, which I'll come on to shortly. So that's by way of background. Put in a nutshell, the statutory nuisance regime gives local authorities legal tools to prevent, take action against certain types of nuisance. And it also allows individuals to obtain an order from the magistrate's court preventing a nuisance that is affecting them. And it's not linked to property in the same way that private law nuisance claims. Anyone affected can bring those proceedings. So it could be an occupier of a building, for example, it could be a tenant, it could be local people in the area. It's much broader in scope. And as I say, to my mind anyway, maybe we can talk about this a bit more in the Q&A, the real advantage of the statutory nuisance regime is that it offers a much quicker and more cost-effective option where nuisance is a problem, which obviously makes it much more accessible to a wider range of people. Next slide, please, James. So if we start getting into the nitty-gritty then of what a statutory nuisance actually is, you can see the definition is in section 79, and there are various types of environmental problem, if you like, which will come under the definition. And so, for example, if we take B, smoke emitted from premises so as to be prejudicial to health or a nuisance, and of course we're talking about noises and smells, that smoke may smell unpleasant, for example. And you can see that there are all sorts of problems, some of which quite novel, animals, for example, even insects, which are capable of forming the basis for a statutory nuisance. Next slide, please. But you will see that it's not just about identifying the problem. You've then got to ask, so I gave the example of smoke emitted from premises, is that problem prejudicial to health? That's one way of falling within the definition. Or is it a nuisance under common law, as I said at the beginning? So if you want to come under the prejudicial to health element of the definition, that's defined as injurious or likely to cause injury to health. And I say there that in practice, you can't just say in very general terms, oh, that's prejudicial to health. You'd need to identify a specific health problem, health condition, and then you need some expert evidence to link the two. In my experience, the more common way of framing the statutory nuisance is with reliance on the common law definition of nuisance, which no doubt you'll remember from law school, but in a nutshell, it's unreasonable interference with the enjoyment of land. And in judging whether the interference is unreasonable, you need to look at all the circumstances, but the case law stresses in particular the importance of things like the nature of the locality or the neighbourhood, and that you may remember there was the very famous observation from the Sturgis and Bridgman case that what may be a nuisance in Belgrave Square, and I put a photograph of Belgrave Square there, although it may have changed since that judgment, will not necessarily be a nuisance in Bermondsey. So the point is you need to look at the context carefully. Although indeed, I think last time I went to Bermondsey, it seemed very upmarket. So that's maybe not the best comparator in this day and age. But anyway, duration, time and frequency. So if it's just a one-off event, if we take noise, for example, if there was just a loud noise on one occasion, that's unlikely to be a nuisance. We've got to think about sensitivity on the part of the complainant. You know, just because you're particularly sensitive to noise and have much lower threshold than anyone else is not going to establish a nuisance. And then you need to think about malice as well. Next slide, please, James. So once you've established that on the face of it, the environmental issue, the noise or the smell comes within section 79, you then need to look at the exclusions that follow on later in that section, because there are certain types of issues that would prima facie be a nuisance, which are then excluded from the regime. And to put it crudely, really, there are exclusions where there is another regulatory regime which deals in a comprehensive way with the particular problem. And I suspect we will come on to talk about this in more detail. But one good, just because it's a very clear example, is contaminated land. You'll know that that's dealt with under the same Act under Part 2A. And so because there's that very comprehensive regime for dealing with contaminated land, it's then excluded from being a statutory nuisance. So you'd need to go through the exceptions carefully for your particular smell or noise to see whether it is excluded. And it is all, I mean, we'll come on to this, but it's worth saying there may, if it's not excluded, then effectively there is an overlap in regulatory tools. So just because there's another regulatory regime that may tackle the same problem, that means that there's more than one option available effectively for dealing with the problem. The slight caveat to that is section 7910, which I know can cause local authorities some real difficulties and indeed angst on occasion. What that section says is that a local authority can't institute summary proceedings So effectively a prosecution for a nuisance for failing to comply with an abatement notice for without the consent of the Secretary of State for certain types of nuisance, that includes noise from premises, where effectively that issue could be prosecuted under the environmental permitting regime. Now, there's a few things to say about that. The first is that, of course, not being able to prosecute is different from serving an abatement notice. So even if the issue is dealt with under the environmental permitting scheme, there's nothing to prevent the local authority serving an abatement notice. And in fact, well, I would probably say that they're required to. You may say, what's the point of an abatement notice if you can't then enforce via criminal proceedings? But anyway, we can talk about that in due course if people are interested. And the other thing to say is that, of course, it's not an absolute bar, it's just a case of obtaining consent first. And I have come across instances where the consent has been forthcoming. And really, I think it's just a matter of, well, I don't want to, I'm just say just a matter, I appreciate it can be difficult, but communication with the Environment Agency is absolutely key. You know, if it's a serious problem, you need to be communicating at an early stage. And if the Environment Agency are dealing with it, then that's a situation where consent is unlikely to be forthcoming. But it may be, if it's something that's not particularly high, not particularly serious on the Environment Agency's agenda, that they're more than happy for the local authority to deal with it. So anyway, I wouldn't be necessarily put off by section 79(10). Okay, next slide then, please, James. So we're now on to part 2, which is all about the role of local authorities. And I've summarised there the main things that a local authority has to do. You'll see, first of all, there's a duty to inspect the area on a periodic basis to detect any statutory nuisances. There's also a duty then to investigate a complaint of statutory nuisance insofar as reasonably practical. Where a local authority is satisfied that a statutory nuisance exists, they're required to serve an abatement notice. And there's a bit more detail on the slide about that. I suppose the key point to stress is that almost inevitably there's going to be significant professional judgment, in other words, discretion, typically exercised by the environmental health officer in making that decision. So yes, as I say, they can serve an abatement notice. And then noise, there are slightly more options, more informal options in relation to noise. Effectively, the local authority has 7 days before serving an abatement notice to think about other things it might do. So, I mean, typically, it will often involve speaking, informal correspondence, communicating with the person responsible for the noise nuisance, and trying to persuade them to stop making it before any formal steps have to be taken and a formal abatement notice have to be served. But ultimately, if that fails, then the duty to serve an abatement notice kicks in. Next slide, please, James. So we're in a scenario where an abatement notice has been served, and that does quite often do the trick itself. But if it doesn't and the recipient fails to comply, what can the local authority then do? Well, they can prosecute for the offence under section 84, because it's a criminal offence to fail to comply with an abatement notice without reasonable excuse. That's their first option. although, as I said, NB, the exception at the beginning about overlap with environmental permitting, so you need to have a think about that. The second option for the local authority is abating the nuisance itself, and then it can claim reasonable expenses for taking that action. And that typically happens where the nuisance is quite serious or urgent and the local authority feels that it needs to be dealt with quickly. And then the kind of final really desperate situation, really serious scenario option is to seek an injunction. But as I say, and that would have to then, and part of the test for that is if it's considered that summary offence proceedings wouldn't afford an inadequate remedy. So as I say, that's only going to be appropriate in extreme cases where these normal options are not going to be appropriate. Next slide, please. And then the other important point to say, because in terms of practitioners, this makes up a lot of the work, there's a right to appeal against an abatement notice within 21 days, and the appeal is to the magistrates' court. The grounds of appeal are in the Statutory Nuisance Appeals Regulations 1995. I've set that reference out on the first introductory slide, and I've summarised what the grounds are at the bottom of the slide. Effectively, no statutory nuisance, a material defect in the notice, and the requirements of the notice might be disproportionate to abate the nuisance. The best practical means defence, and then in respect of noise, that the requirements of the notice go beyond controls imposed under other regulatory regimes. I should probably say a little bit about the best practicable means defence, and I should say I could give a whole talk on this issue. Which I would be quite happy to if people think that would be helpful. We can contact Chambers afterwards. I'm not going to go into lots of detail, but in a nutshell, it's a defence for some types of nuisance to show that the best practicable means were used to prevent or to counteract the effects of the nuisance. And that term, BPM, it's defined in section 79(9), and really it's a case of assessing best practicable means in all the circumstances. So the statute says you need to look at things like local conditions and circumstances, the current state of technical knowledge, the financial implications, the way that the design, installation, maintenance, manner and periods of operation. There can't be any incompatibility with a duty imposed by law or indeed with safe working conditions. So some people call this defence a polluter's charter because effectively you could say, well, you know, sorry, we've done our best, nothing we can do about it. But obviously it's going to, I mean, I think that's a bit simplistic. It's going to depend on the particular case, but there is a potential defence if it can be made out on the facts. Next slide, please. So we have we're talking about appeals against abatement notices, and there really I've just set out what the remedies are that the magistrates court can grant on an appeal, and I set out the general position that the requirements of the notice are suspended until the appeal is determined. In terms of procedural matters, James, next slide please. These appeals are they lie in the weird and wonderful civil jurisdiction of the magistrates' court. So I've set out the relevant procedural rules you'll need to look at. I have to say, I do really enjoy these sorts of strange bespoke hearings that the magistrates courts do. There's quite a lot of environmental matters that for some reason appeals go to the magistrates court. And I mean, for example, I did one recently on zoo licensing, all about the size of elephant enclosures, talk about weird and wonderful. But I suppose the downside of the weird and wonderful is that the magistrates court is not really set up for these kinds of proceedings. And you may think that you don't know very much about, you know, a particular niche area, but I can guarantee that you will almost certainly know more than anyone else there at the magistrates court about this particular area of environmental law. But what that means in practical terms is that you really need to think carefully about the procedure and how you're going to best fit this type of proceedings into this particular type of court. So in my view, really important where possible is for constructive dialogue with the other side, so that things like directions can be agreed as much as possible. And a first directions hearing is going to be really important in terms of setting out how the proceedings are going to run. I strongly suggest that you request a district judge rather than a bench of magistrates, because a district judge is going to be more likely to be comfortable dealing with this sort of case. So anyway, although it's quite fun being in the magistrates court for those of us barristers that don't do criminal law and are secretly jealous of our criminal colleagues, that forum does pose some difficulties and you need to think about them. Next slide, please, James. I'd better just speed up on the last bit. In terms of action then by individuals, which is part 3, as I said, there's an entitlement to issue proceedings in the magistrates court under section 82, and that's by anyone who is aggrieved by the existence of a statutory nuisance. And it's a really powerful tool where an individual wants to take action themselves. It may be that the local authority has exercised its legitimate professional judgment to find that there is no statutory nuisance on the facts, or it may be that the local authority, for the reasons I went into, can't do very much about it. It might be the type of nuisance that, because of the need for consent to prosecute, because of an overlap with the environmental permitting regime, that the local authority can't really take it further. So actually, it can be much more effectively tackled by an individual. In terms of what the magistrates court can do, what would be the remedies that you can get if you issue proceedings in this sort of action? They can make an order requiring the defendant to abate the nuisance, and it's a criminal offence not to comply with that order, so pretty strong tool. There's a power to impose, these are all additional, I should say, so they can be cumulative. There's a power to impose a fine up to level 5, which last time I checked was £5,000. And there's also a power to award compensation up to £5,000. So again, going back to the very beginning and common law nuisance, if your primary objective is damages, money effectively for a loss in property value, then clearly this isn't going to help you very much. But if actually the purpose of the proceedings is just to try and stop the nuisance as quickly as possible and as cost effectively as possible, this is a really powerful tool. In terms of the procedure and practical considerations, next slide please, James. Now we're back in the sort of criminal remit of the magistrates court. These proceedings are criminal in nature, so the criminal procedure rules apply and the criminal standard of proof applies, so it's beyond reasonable doubt. In terms of procedure, 21 days of advance written notice of the intention to issue proceedings need to be given. And then it's a matter, just as with other criminal offences, of laying in information with the magistrates court, who then in turn issue a summons. to kick things off. Importantly, there is provision for costs to be awarded. In fact, there's a statutory entitlement to expenses properly incurred in bringing the proceedings if the nuisance is found to exist when the proceedings were issued. The flip side of that, if someone bringing the proceedings loses, and this is why lots of people like this route, the risk of an adverse costs order is limited, because in practice the defendant's likely to be awarded their costs out of central funds. I've now been going for half an hour, and I think I've covered everything on my whistle-stop tour. So without further ado, I will hand over to James.
Brilliant. Thank you so much, Katherine. And what a vivid picture you painted, that we've all enjoyed turning up at the magistrate's court to deal with a complaint, and the ripple of excitement that goes around the entire court when they discover that there's something that is non-criminal occurring. So I am going to be dealing with other tools. Now, as I said at the outset, because unfortunately Rose Grogan cannot be with us at the moment, but will be providing her bit of the talk at a later point. She will be dealing with environmental permitting and sections 33 and 34 of the EPA 1990, so waste. So once you have Rose's bit, along with Katherine's fantastic contribution that you have just had, that should then mean that we're down to looking at some other, in my view, quite interesting tools that are available to local authorities and others when we come to item 3, but mainly available to, as regards 1 and 2, local authorities to address noises and smells. Now, the first place I want to look at is the role of the town and country planning system. Now, of course, when a new development is going to introduce unwelcome noise and smells, or rather might introduce them if it's not properly conditioned, then the local authority has a range of tools at its disposal, whether they be gramping conditions or non-gramping conditions, and equally the planning regime will ensure, or is meant to ensure, that it marches in step with, for example, the environmental permitting regime, and we don't have duplication of effort. So if something will be dealt with by the environmental permitting regime, the local planning authority are enjoined to proceed on the basis that that regime will function as it ought to, and they shouldn't worry about conditioning matters that will be dealt with by an environmental permit, and of course close working with the Environment Agency on the part of the LPA is always advised. But what is interesting, in my view, is looking at the other type of problem that arises, namely where one has a, shall we say, of itself benign new development, and the classic example, of course, residential, that is proposed for a site in sufficient proximity to an existing operation, whatever it be, a factory, a mushroom farm, perhaps, with a wonderful yard full of chicken litter, whatever it may be. And the new development, because of its proximity and its nature to that existing operation, is likely to, or there's a risk that it's going to cause problems for the existing business, because it's an agent of change, and by landing where it's proposed to land, it may lead to complaints and so on and so forth. Now, just to let you know, I have 3 pictures in these slides, and I will be inviting anyone who believes they can correctly identify the existing receptor at issue in each of the sites to submit an answer via the Q&A, and I will tell you at the end if you've got it right. you don't have to submit the answer. You can just keep it in your head. So that's the first slide. I will not reveal what the existing receptor at issue there was or is. Now, it's interesting to trace the evolution of the agent of change policy, because it's not that long ago that that the courts were telling us that really it was only in quite limited circumstances that an existing business could actually rely upon the impact upon them of a new development as what I would term a mandatory material consideration. You'll recall the very helpful distillation of the principles as to considerations that are mandatory material and those that are not. In the Samuel Smith case regarding Greenbelt in the Supreme Court not that long ago. But in essence, we have some considerations that, because of statute or policy, are either expressly or by necessary implication, they are absolutely material considerations. Others that may be mandatory material considerations because on the particular facts of the case, only an unreasonable decision maker would disregard them. So there's a Wensbury test. What the Court of Appeal said not that long ago in a case called Forster is that it's only in certain circumstances that an existing business could actually rely upon the impact upon it of new development as a mandatory material consideration. And the example that the court was considering there, of course, was a planning inquiry, and Lord Justice Lord laid down some fairly onerous requirements. It's got to be clearly raised, properly argued, sufficiently particularized, and so on and so forth, with supporting evidence. Now, that, in my view, that is now in the past, because national planning policy contains, and it's not just national planning policy, many statutory development plans at a local level also contain now an agent of change policy. Let's just look at the paragraph in the national planning policy framework that is the agent of change policy paragraph. It's paragraph 182. So planning policies and decisions should ensure that new development can be integrated effectively with existing business and community facilities, and there's a list. And the key, this is the key, existing businesses and facilities should not have unreasonable restrictions placed on them as a result of development permitted after they were established. Where the operation of an existing business or community facility could have a significant adverse effect on new development, including change of use in its vicinity, the applicant, and this is the agent of change as they're called, should be required to provide suitable mitigation before the development has been completed. Now, really fascinating exercise that this requires a local planning authority to go through. Why is it fascinating? Why is it so interesting? And I should say at the moment that there is a dearth of case law dealing with agent of change. There are certainly inspectorate decisions, and I'll mention one of them, and of course it's something that's dealt with by local planning authorities at the determination stage all the time. But there is a dearth of case law. And that means that we don't have anything authoritative from the courts yet as to what it is constitutes an unreasonable restriction. That term is undefined. Now, I think we can all imagine that what a court is likely to say if asked that question, that it's something that's fact dependent, and it will be fact and degree for the decision maker, as to which they will be afforded the usual deference under the Wensbury test. But we can probably guess that the arrival of a new development that would force the closure of an existing business, that probably amounts to an unreasonable restriction. Doubt that there would be much room for argument or debate about that. But I mean, what about the other end? Because let's postulate that if you if you put a resi development here, and there's a noisy factory already over here, there will be complaints of statutory nuisance from those new residents in the new development. But what if, after going through the rigmarole of the receipt, shall we say, the receipt of an abatement notice from the local authority, it's likely that the existing business would be able to make out grounds of statutory appeal, so actually see off the notice. Is it an unreasonable restriction that it has to be fending off and dealing with these complaints? I mean, these issues are presently unresolved, and they are there to be grappled with. Equally, what are the limits of Section 182 in terms of how far authorities, planning decision makers, can rely upon it in essentially forcing new proposals to alter? Can they go as far as refusing permission based on paragraph 182? Because the paragraph speaks very much in terms of mitigation, but what if the agent of change can't mitigate the new development such that it won't impose unreasonable restrictions on the existing facility? Take a typical example, back to noise again, but it just comes up so often. It's often one finds myself going around in something of a loop. The local authority will say to the applicant for planning permission of the resi development, well, we think we think you need full-on noise, mechanical ventilation, and the applicant for planning permission will say, well, I want to be able to sell these apartments with the windows openable because that's attractive to the market. And the local authority, it may decide to impose a condition that the windows won't be openable. In some circumstances, there may not be a solution though. One example, which I dealt with not that long ago, involving a nightclub, which I will anonymise for now because it's my third picture, was a new resi development on a site where there was an existing nightclub, and the proposal was that this existing nightclub was going to be essentially slightly relocated within the new resi development, and the resi development would be built around it, literally on top and around it. And the issue that, in fact, the planning inspector there had to confront was that whilst there was quite a lot that could be done around noise insulation to make the new development probably work with what the existing nightclub was doing at that moment in time, if that existing nightclub, which was actually relatively on the bar type, talking type nightclub end of the spectrum, if it moved to a more music orientated operation, which it might well do, then there would certainly be noise complaints and it might have to close. And there was no way that the new development as designed could effectively have a building within a building to sufficiently insulate the nightclub to prevent that. And in fact, in that case, the inspector dismissed the appeal, refused planning permission on that basis, as well as a heritage basis, but that was a standalone basis. Other issue this agent change policy throws up is the risk that the local authority is accused of fettering its discretion when it comes to statutory nuisance, because it's inevitable that this policy will mean in certain cases the local planning authority has to consider the likelihood of statutory nuisance abatement notices being issued, and of course note that the fact that there is the prejudicial to health limb of statutory nuisance means that one cannot rely as an existing business on the fact that the character of the neighbourhood is as it is, which would of course often usually be a defence to a common law claim in nuisance, the prejudicial to health limb is blind to the existing character of the neighbourhood, in fact. So that requires the LPA to look at that likelihood of statutory nuisance an abatement notice being served. It's an uncomfortable exercise because the LPA might want to say, well, we just don't think that's not going to happen. We're going to grant planning permission, we're not going to serve an abatement notice, but they're fettering their discretion, potentially, or creating a legitimate expectation that they won't pursue statutory nuisance. It all gets very complicated. And how does the agent of change policy fit with growth areas in the new planning white paper? Very interesting question. If an area it has its effective outline planning permission for C3, are local planning authorities going to insist on mechanical ventilation to protect existing businesses? That's a wonderful one to tease out. So that's the first area. Second tool is a community protection notice. Now, perhaps not widely appreciated, but these notices are available under the Antisocial Behaviour Crime and Policing Act 2014, Section 43. I've set out the key bones of Section 43 there. And what is relevant about these notices is that they can be issued in respect of conduct that is driving to the heart of things, potentially a statutory nuisance. There is, in my view, unquestionably risk of overlap. And the reason that this may come into play, and Katherine has already touched upon it, is that not bar, because it's not a complete bar, but that obstruction to a local authority instituting summary proceedings under the statutory nuisance regime, where, to cut a long story short, the statutory nuisance is something that might be dealt with under the environmental permitting regime. Now, if a local authority finds itself unable to pass that obstacle because it cannot gain the consent of the Secretary of State, might they use a Section 43 notice? Well, actually, they might, yes. And there's nothing in the two statutory regimes, in my view, that would stop them doing so, which the recipient of such a notice may think is jolly unfair. Now, there is, it's not as if Parliament hadn't thought about this, because the explanatory notes to the 2014 Act expressly envisage the possibility of a community protection notice, even if the conduct would be a statutory nuisance, as does the relatively recent statutory guidance. It's all very well for the guidance to remind authorities that the specific trumps the general when it comes to statutory interpretation, but is that going to be an answer? Perhaps not. The answer probably to the problem that the recipient might find themselves in is that it would be, in my view, a very brave magistrate's court faced with an appeal against one of these Section 43 notices that decides that its requirements are reasonable, or the conduct is not unreasonable when the environmental permitting regime isn't interested in dealing with it. So that's that second tool. And then the third one, which is now very much moving away from the world of local authorities to private individuals who perhaps in that unfortunate case find themselves faced with noise or smell, or indeed certain other so-called physical factors that arise from the use of public works that enjoy statutory immunity from suit in nuisance. There is, in those circumstances, in respect of new public works or new alterations to existing public works, there is a money remedy available under Part 1 of the Land Compensation Act 1973, or at least potentially available. And that remedy is typically available to homeowners who, by reason of the use of those public works or the public works as altered, see their home diminished in value by a closed list of physical factors. It's only a monetary remedy, I emphasise that. The list of physical factors is not all encompassing, but it's not far off. It includes noise and vibration, smell and fumes of smoke and so on. The public works, what is caught by that? Well, highways is the classic example. Also, though, aerodromes that benefit from immunity pursuant to Section 72 of the Civil Aviation Act. So essentially, one is looking at licensed, certified aerodromes, the larger aerodromes, and other works that benefit from immunity from suit. That is a remedy that many people around airports in particular find is ultimately the only remedy available to them, and it's one to bear in mind. It's perhaps rough justice, but it is better than nothing. So that is, I hope, a relatively rapid run through some other tools that are available to deal with noises and smells. Now, Katherine, can I invite you to reappear, and I will stop sharing. Hello, and shall we have a look at some Q&A?
I've been having a look while you were talking, James. Do you want me to just pick off a couple that are very much on my topic, because some recent ones
are very absolutely much yes, go for it.
There are a lot of questions for which I'm really grateful, because it shows that we haven't just been talking into a vacuum, so thank you. It does also mean that we're probably not going to be able to answer all of them, but we will do our best to at least do a few. I've been asked whether an obstruction to a highway, so such as an overgrown hedge blocking a footpath, can be a statutory nuisance. And I'll deal with that first because I think it's relatively straightforward. My understanding is that the answer is no. There's a case, Westley in Hertfordshire from 1998, which says statutory nuisance does not apply to obstructions to the highway. And that's because the Highways Act 1980 contains its own procedure for dealing with obstructions to the highway, including a procedure where an aggrieved person can go to the magistrate's court asking for an order which effectively compels the local authority to remove the obstruction. So that's that one. Another question, which is quite an interesting one, is how often noises and smells have to occur for the definition of a nuisance to be met. And the person's given an example of a factory that causes a smell maybe 2 or 10 times a year. And I'd be interested in James's view, but really I think, and sorry, this is a bit of an annoying answer, but it really does depend on all the circumstances. And I'm thinking in particular, it's not just the frequency, but the length of each of these incidents of smells, if you like, because say you only, quote unquote, have a bad smell 4 times a year, on the face of it, that's not very often. But if that bad smell lasts for several days, maybe even weeks each time, that's all going to tip in favour of there being a nuisance. It would obviously depend on the severity of the smell, how bad it is and how unpleasant it is, and of course the area. And back to my Belgrave Square and Bermondsey, the courts are likely to think that some areas are going to be more tolerant of smells than others. James, do you have any further thoughts on that?
Well, look, Catherine, you're absolutely right. I'm afraid it is incredibly fact and circumstance specific. We look, of course, for whatever help and assistance there is to be gained or gleaned from case law, but we do so with the massive caveat that each case turns on its own circumstances. I mean, just calling to mind, and apologies for stepping outside statutory nuisance to do so, but calling to mind Lawrence and Fenn Tigers, where one has to dive back from the Supreme Court all the way, in fact, to the first instance to remind oneself what it was the judge at first instance ultimately decided should be the terms of the injunction there. And if one wants a starting point for what might be an acceptable frequency and level of noise experienced by a residential property at a certain distance from a motorsport venue, then sure, you know, one can take Lawrence and Fenn Tigers as a starting point. Even then, even on such carefully circumscribed facts, it's only a starting point. I think the person who asked the question referred to Bar and Biffa at first instance, and of course that part of the judgment, and the rest of the case was about other things, but that part of the judgment certainly still stands, and it made it clear that it's not going to be something that's a one-off. At least it would be very, very, very unusual one-off to actually cause a statutory nuisance to have occurred. But I mean, perhaps we could actually use this as a springboard to look at another question we've had, which I think is related and interesting. Can prejudicial to health also include mental health? Now, there's not on the face of the statute an elaboration of the definition beyond that which Katherine has already set out. And certainly when one considers that environmental health officers, environmental protection officers, on a very regular basis, when it comes to noise, are having to consider the impacts of noise, particularly at night, on sleep. There will be some people on this webinar who are infinitely familiar with the World Health Organization guidance and the British standards, and so on. And of course, we'll know that it's recognized that sleep disturbance can certainly have health impacts. I mean, that seems to be actually quite an obvious example where prejudicial to health, at the very least, straddles physical prejudice to health, as it were, and prejudice to mental health. I mean, Katherine, I don't know if you have any further views on that rather interesting question.
Yeah, I agree. It's a really interesting question. I mean, I think it definitely applies to mental health, and I think if it didn't, that there would be a case for some kind of legal action under the Equality Act, or indeed under Article 14 of the Human Rights Act, to exclude mental health. I mean, obviously I'm talking about a specific diagnosed mental health condition with the relevant supporting evidence. But on the face of it, if the nuisance is genuinely, for example, James's example of, you know, serious news at night time, giving rise to mental health problems, then absolutely, I think it's entirely appropriate to use this regime. And one might even say that's exactly the kind of scenario in which it's appropriate to do so. Also linked to this question, I see someone's asked, I presume from a local authority, whether it's appropriate to serve an abatement notice if the noise arises from shouting from somebody with a disability, and I assume the shouting's linked to the disability. I mean, appropriate. I suppose there's sort of a policy question about that, but I would just refer you to a case which deals with precisely this question, a very recent one, Fisher against Durham County Council, 2020 EWHC 1277 admin. And there effectively it was a judicial review claim, but there the High Court upheld a local authority's abatement notice, their decision to serve one who'd done exactly that, and it was found that in the circumstances it was done as a last resort, it was proportionate, it struck a fair balance between the needs and rights of the individual and the community. So I would have thought, you're going to have to be very careful on your particular facts, and I think it would be important to explore other alternative avenues first, and make sure that you've done that really diligently. But if it does really seem that an abatement notice is a last resort, then based on the Fisher case, yes, and obviously make very sure that you've documented your obligation to have due regard to the public sector equality duty in making that decision.
Absolutely, and of course in Fisher there was no doubt at all, right, isn't it, Katherine, in Fisher, that the protected characteristic, I mean, it certainly went directly to the unfortunate person at the heart of that case, the protected characteristic at issue, but nonetheless, because the local authority had done all manner of other things first, as you say, it was a lawful approach. We've got another one. Can a nuisance, I think can an abatement notice still be served on a development, even if it is emitting noise which complies with its planning condition? Well, my view on that is absolutely yes, and that is because we come back to it, but the statutory nuisance regime does not turn on what is in a planning permission. Certainly, the prejudicial to health limb does not turn on what is in a planning permission, but nor, in my view, does the other limb based on common law nuisance. And of course, you go back to Byron, Biffer, and Lawrence and Fenn Tigers regarding the relevance, but there's certainly non-determinative nature of planning permissions when it comes to nuisance. So the answer is yes, but equally one would expect that the permission would be relevant to an appeal against the notice and so on. The questions are coming in, Katherine. Do you want to pick another one?
Well, there's a couple that have asked this, or maybe even three now, about lockdown and the coronavirus context, and whether we've experienced more instances of noise complaints due to just people living more differently and being cooped up at home more, and linked to that, whether a change in the baseline amount of noise, if there's less traffic, for example, outside, does that mean that more noise will be tolerated? I have to say, I haven't, but it may be that they just haven't kind of filtered through to the point of instructing council. I haven't myself seen an increase in these types of claim. I mean, I've definitely seen some advisory matters linked to complaints about noise, but I think not directly linked to coronavirus baseline levels of noise changing, if that makes sense. So I wonder if James has experienced otherwise. But I think the more interesting question is about this change to the baseline, and I think really that will depend on whether this becomes a permanent change or not, because if the baseline has been drastically reduced on a temporary basis due to a public health crisis, then I think it's going to be quite difficult to persuade a court, well, maybe difficult to persuade a court that there's now a nuisance where there wouldn't otherwise be one, just because the noise is more noticeable on this very temporary basis. But if, and I suppose nobody really knows the answer to this yet, if we as a society change in the long term so that our working habits mean that most of us are working from home, and that there is much less traffic noise generally, and transport noise and other types of background noise, then yes, quite possibly, there will be a permanent change to the baseline, and that could, exactly like one of the questioners suggests, mean that claims can be made out for a statutory nuisance that couldn't previously in the past. James, I wonder if you have any further thoughts on that, because it's quite an interesting question.
That's absolutely right. Look, the properties that at present, and this will happen in any event, COVID or no, and working from home or no, as electric vehicles roll out, because the properties that at present experience a background level of noise due to road traffic noise, and it may of course be a highway that's some way removed from the property, but still the road traffic noise is there. That background level of noise is going to be reduced over time, simply because we'll be losing the engine noise. We won't lose the tyre noise, although of course highways authorities have done a lot of work on surfaces that reduce tyre noise in the last few decades. As regards the, I suppose another question, are we actually? I mean, are we seeing more complaints of nuisance since COVID? Actually, the opposite in my experience, actually, and that's and I have to say I don't think that's because environmental health officers are not going out and looking at things. Actually, I think because it is because as a society we have been that bit more considerate over recent months, but that will not last forever, I'm sure. Katherine, I think we should probably wind up, and unless there's a question that you're really burning to deal with, but I'm conscious that we've already comfortably exceeded our 39 minutes starting point time allocation. Is that all right?
Yeah, absolutely.
Great. Good. Well, look, thanks very much, everyone. Thanks in particular to Katherine for an absolutely cracking presentation. And of course, we wish Rose family well. I think that means that I simply need to end with, if I can, the final slide that I seem to remember I promised, which would be the 3 photos and reveal the identity of the existing receptors that were at issue. They are all of them nightclubs or live music venues of different stripes. The one in the top left, that is of course the notorious development near the Ministry of Sound. That's the new Eileen House that led to such a wonderfully complicated Section 106 agreement, and new leaseholders sign up to all sorts of obligations. The other one is the George Tavern, and it was the proprietor of the George Tavern, Mrs. Forster, who fought so long and hard and has to be said successfully through the courts and inspectorates to keep that operating as a live music venue, albeit now with some resi fairly close to it, but lots of insulation. And then the bottom left is the most, I mean, if anyone gets this, then I salute them, but that is in fact the entrance to the Backstreet Club, which is just off the corner, the big junction of Mile End and Burdett Road, near the wonderful swooshing green bridge that goes up eventually to Mile End Park. And that is the case I was referring to, dealt with at inspectorate level fairly recently, where the developer proposed to build a pretty sizable resi development on the site, which is a reasonably large site, and actually move that club down into the basement, so reinstate it in the basement. And whilst based on its existing operation, which was, as I say, as a more like a bar operation, it seemed that with insulation as mitigation, that club could be preserved without the risk of statutory nuisance proceedings, complaints, and so on and so forth. If it switched to a more music-orientated venue, then it would certainly be at risk. And because of its particular characteristics, it is, I think, the country is probably Europe's actually leading gay fetish bar, of obvious importance to the LGBTQ plus community, the inspector decided to refuse the development permission on that basis. So if you've got all those three, well done. Okay, thanks so much. Take care, everybody. Cheerio.